Hello again. In this video I'm going to talk to you about Australia's legal relationship with the world. It's important for Australian lawyers and indeed Australian law students to understand the specific features of the Australian legal system, but it's also important for us to understand the ways which our legal system differs from other legal systems in the world and how we understand our legal system operates in the international legal order. When we speak of international law, we mean, in general terms, the law that governs the relationship between nations, sometimes called states. And those are different from the states that we have within Australia. This law is typically made up by international action rather than the act of individual governments. The main sources of international law include three things that I want to talk to you about today: international agreements, the decisions made by international legal bodies, and international custom. So turning first to international agreements. As the name suggests, these are agreements negotiated and ultimately entered into by two or more nation states. International agreements of this kind can be known by different names. You'll be familiar with the idea of treaties or conventions, but sometimes they're called covenants or other names. Secondly, we have the international decisions, declarations or instruments that are made by international legal bodies. Many of those bodies are established by international agreements. The most important body that we're generally familiar with is the United Nations, or UN. But there are other international bodies like the international courts, the International Court of Justice, and the International Criminal Court are some examples of those. And third, we have international custom. Those are the rules that are developed over many years by which nations now consider themselves bound. They're sometimes quite difficult to pinpoint or articulate, but they still operate in the backdrop of the international legal system. Now, even though I've said that international law is the law that governs the relationship between nations, it doesn't only deal with strictly international matters. There are international legal principles covering a whole range of topics, subjects or concerns. So, for instance, there will be international legal principles concerning environmental standards or protection of human rights, or international criminal law. Some of these are issues that really are regulated or take place wholly within a nation state, but the international order or the international legal framework has decided that there is a kind of collective approach towards those issues, which originally we might have thought of as domestic or internal national issues, but have now become of international concern. Turning then to Australia. Australia participates in the international legal realm in many different ways. First, we need to be clear on the role of the executive in our system. In our system, it's the executive government that has the authority and the power to enter into international treaties and arrangements with other countries, or within the UN system. It does so on Australia's behalf, but it doesn't need anyone else's permission to do that. So the executive can go ahead and sign treaties and covenants or make undertakings or promises in the international world without waiting for the authority of Parliament or some other operator in our system. The executive has the full power to engage in international relations. That means that the executive government can go ahead and engage Australia as a party to all or any of the international legal framework or legal instruments. And Australia is, of course, a party to many international treaties and covenants, and many bilateral treaties with other nations and multilateral treaties with a number of different nations. The important point to take from this is that whilst the executive might have gone ahead and made all those arrangements, that doesn't necessarily filter down into Australia's domestic law until something additional happens. So the executive can go ahead and make those arrangements with our friends at the international level, but it won't become part of Australian law until Parliament implements those treaties or arrangements or covenants. So we have in Australia what's known as a dualist system. International law that we undertake to be a part of at the international level does not bind anyone in the domestic level until this additional act takes place. That is, that the federal parliament implements that international standard or undertaking into Australian domestic law. So the international acts that we undertake are a signal to the international world that we agree to be part of the international legal framework. But we're not obliged in the domestic sphere to implement that until Parliament decides to do so. Even if there are mechanisms for enforcing international law and making that international law obligatory in our nation, they don't become obligatory until the Australian Parliament or the Federal Parliament implements those international mechanisms. The important point, I guess, that I want you to take from this is that international law doesn't operate as a higher law in the Australian system. It doesn't operate as controlling or limiting any of the Federal Parliament's powers. It operates as a different realm of law. The effect of international law in any nation state will be dependent on the constitutional system in that state, and in our system it doesn't become binding. In many ways we can understand this dualist system as an example of parliamentary sovereignty, because the federal parliament retains the sovereignty, the right to make the decision about what becomes part of Australian law and what doesn't, even though the executive government might have signed up to certain obligations in the international stage. Now, international law still has significant influence in Australian law. It can influence our law, of course, directly when Parliament implements a treaty or an international agreement, but it also can influence us indirectly. For present purposes, we can say that international law is not always directly relevant to Australian public law, but it can become so. The fact that something is prohibited or permitted by international law does not make it an issue of whether it's legally valid or invalid within Australia. Whether it is legally valid or invalid in Australia will depend on whether the Australian Parliament, the Federal Parliament, has actually implemented that standard. If the standard remains unimplemented, it's just an obligation that we have vis-à-vis our international friends, but not within the Australian public law system internally. International law can still serve as an important standard for us in domestic law. It can still indicate to us what we expect our domestic parliament to do, what we expect our executive to do in terms of conforming with a standard that all other countries, or many other countries, are adhering to. But it doesn't force our government to do anything. It's interesting to look at the different international standards that we expect Australia is bound to and consider whether we are actually bound to do those in our domestic sphere. That's all for today. Thanks.